Andre will talk about ethical considerations in the sorry, I've got some side music there. Andre will talk about ethical considerations in the context of insurance and professional liability, and I think taking a laser-like narrow focus. Over to you, Andre.
Thank you, Michelle, and welcome to all of you. Thank you for joining us this afternoon. Just a little bit about my practice. I have a broad commercial litigation practice, but one area of interest to me is the area of professional responsibility. And I've run a lot of cases for law cover and various barristers, insurers defending solicitors and barristers against professional negligence claims and also claims for personal costs orders. I also sit on one of the Bar Association's professional conduct committees where we consider disciplinary claims against barristers. And what I propose to address in the short time allocated to me today is the interplay between the ethical and professional obligations imposed on solicitors and barristers and the ways in which breaches of those obligations can have disciplinary consequences as well as personal cost consequences. And that's also relevant for insurance purposes because absent fraud or dishonest conduct, a disciplinary or personal costs claim will invariably be covered by the solicitor or barrister's professional indemnity policy. Now, I've only been allocated 10 minutes to speak to this matter, and so it'll necessarily be a brief overview, but I propose to do three things. Firstly, to identify the relevant statutory provisions and some of the key authorities. Then secondly, to give some examples of where issues can arise. And lastly, to finish with a few suggestions for how to avoid ever facing these difficulties or what to do if you find yourself in that unfortunate position. So firstly, in relation to the relevant statutory provisions, I think I have sent to everybody already, but I'm just going to do it again in case it hasn't come through for people who hadn't joined at that time, a short document which hopefully will be with you shortly, where I've set out some of the key legislative provisions that deal with personal costs orders and associated disciplinary issues. And I'll speak briefly to it, but I've given you that document which I hope may be of some assistance. Section 99 of the Civil Procedure Act gives the court power to order costs where it appears that there has been A, serious neglect, serious incompetence, or serious misconduct of a legal practitioner, or B, that the practitioner has improperly or without reasonable cause incurred or caused the incurring of costs for which the legal practitioner is responsible. Immediately, as soon as you see the words neglect, incompetence, misconduct, and improper conduct, it brings into play the considerations of ethical issues and the like. And I've also provided in the document relevant extracts of two provisions of the legal profession uniform laws which deal with professional misconduct, section 297, and unsatisfactory professional conduct, which is section 296. And as you will see, unsatisfactory professional conduct includes conduct that falls short of the standard of competence and diligence that a member of the public is entitled to expect of a reasonably competent lawyer. Professional misconduct can be a substantial or consistent failure to reach that same level, or of course something more serious, including right up to not being a fit and proper person to engage in legal practice. And I've also included the links. They're all hyperlinks in this document, so you can find the legislation if you would like to look at it directly. But I've included the barrister's rules and the solicitor's rules. And that's relevant. Of course, I'm not going to address that now, but that covers, as you're all familiar, a raft of things, including obligations to the court, obligations to your opponent, and the like. But importantly, section 298 of the uniform law expressly provides that a breach of the solicitor's rules or the barrister's rules is capable of amounting to unsatisfactory professional conduct or professional misconduct. Now, what does all of that mean? All of that means is if you've acted something falling short of what's regarded to be proper conduct, it's all a matter of fact and degree, but there's a risk of exposure if costs are wasted or improperly incurred as a result, which could sound in a personal cost claim, but also could result in disciplinary claims. I've also set out in the document some of the key authorities. I won't go to them in any detail, but there's a couple of cases, including which you'll see numbered 1 and 2, which seeks to give some further meaning to what might fall within the scope of improper or unreasonable conduct and the like, and a very helpful extract from the judgment of Justice McColl in Lamoto and Able Technical, which is often cited, which sets out, Her Honour helpfully sets out 8 important matters that the court will have regard to in considering these types of applications. That's a very quick overview of the relevant legislation. If I can then turn to some examples of how this can arise. They're obvious cases, such as, for example, bringing a case with no real prospects of success, making unnecessary allegations or deploying irrelevant or inappropriate evidence, deploying hopeless pleadings that are repeatedly amended, causing an adjournment because of some lack of preparation, or conducting or preparing a case without complying with relevant court rules or procedures. There are less obvious cases. I've just recently been in a case where it was alleged that solicitors who were the subject of a claim for Section 99 personal costs, it's alleged that those solicitors should have realised that the opposing solicitors were operating under a misapprehension as to the effect of some orders made by the court, and should have told those solicitors and or informed them about conduct being engaged in by another defendant for whom they did not act. Now, it sounds unexpected and I'm overly simplifying it, but that resulted in a 6-day trial with days of cross-examination of the solicitors and a reserve judgment. And then there are unexpected cases. For example, I've acted in a case where a man who lost his proceedings, who failed, the claim was dismissed, then brought a Section 99 claim against his solicitor and barrister, alleging that it was their incompetence that caused him to lose the case and waste costs. In fact, he lost because the trial judge didn't believe his evidence. But nevertheless, that case ran for over a week at first instance and then was subject to an appeal. Both the barrister and the solicitor were successful. What all of this shows is you obviously want to do whatever you can to avoid being in any situation where there's an exposure to either disciplinary or personal costs claims. They're very stressful, time consuming, and can have serious reputational consequences, even if it's successfully defended in a judgment. There may be adverse comment made, or even comment and the naming of the practitioner, which can be very, very stressful and problematic. So some tips and suggestions in my remaining minute or so. Firstly, always seek to comply with your professional obligations. Know what they are and comply with them. Prepare your cases as carefully as possible. If your case involves technical aspects or expert evidence, for example, why did a piece of machinery fail and who was responsible, get an expert opinion early to then make sure your case theory and pleading fits with your evidence and that you sue the correct defendants. Don't breach court orders. Keep the prospects of your client's case under review as evidence is served and the landscape changes. Be sure to act in accordance with your client's instructions and make sure you have express instructions when required, and particularly about important matters. And if you need some assistance, consider briefing counsel early rather than later. And finally, and very importantly, if you find yourself in a situation where a claim is foreshadowed, or even where circumstances have arisen in a case that could give rise to a disciplinary complaint, a negligence claim, or a costs claim, be sure to notify your insurer. Put to one side any embarrassment or inconvenience, and contact your insurer as soon as possible to tell them and give them whatever further information they require. And in particular for solicitors who need to notify law cover, I think you'll find that the claims are handled by experienced solicitors who will likely be very helpful and sympathetic to your situation. And I think with that, I've reached my 10 minutes, and I hope that's been of some assistance. Thank you for listening.
Bang on time. Thank you, Andre. Our next speaker is Giles Stapleton. Giles is one of the members of the floor with an interesting spread of practice areas, because he practices predominantly in commercial law and equity, but does a healthy number of family law cases as well. And there's a very symbiotic crossover. So he's going to speak to us about ethical considerations in the family law context, but bringing necessarily an equity perspective. Over to you, Giles.
Thanks, Michelle. Can I just share the screen if possible? It says host disabled participant screen sharing. I'll just see if I can. No, it doesn't seem as though I can. Okay, well, hang on. Yes, thank you. I hope everybody can see that. I'm going to talk about a few issues, and there's probably 7 or 8, and I'm going to speak quickly about each of them because they all represent how it's possible, firstly, to get into a position where you have to be very cautious about your ethical obligations, and also where you have to think very carefully about the advice you're giving and whether that advice is creeping into an ethical territory or just simple advice. Anyway, the first area is that clients do have a tendency from time to time to conceal money, and they do so in various circumstances. The first example I can talk about is when a client did tell me in a conference that they had concealed some money. What had happened was this particular person was a slight celebrity. He had disclosed everything that he wanted to disclose, and during the disclosure process had received a large bonus from his employer, which, apart from his own obligation to disclose, would never have been known to the other side. So my solicitor and I were going along happily thinking that everything that we'd been provided was everything that was available. It clearly wasn't, because in a conference we had with this particular person, there was a disclosure as if we were his confidants about a large amount of money received as a bonus that this particular person had decided he didn't want to disclose, and instead he wanted to convey to an accountant friend of his who would hold it for him pending the conclusion of the proceedings. So obviously, trusted as we were as his confidant, we were then in a very difficult position about informing him of his obligations, and in fact ours, to disclose. He took it extremely well. There was a disclosure letter written by us to say that we'd literally only just become aware of this information, and we had to obviously explain that it was much better to have told us now than it was to disclose it in the witness box under cross-examination. So we were able to repair it slightly, but we absolutely had to tell him and then the other side and ultimately the court about the money and the expected catastrophe in the witness box when he admitted that he hadn't fully disclosed at the appropriate time had the natural consequence that it would be expected to have, which was he was found to be largely dishonest. So that was an unfortunate situation, contrasted with a client who didn't really tell me or the solicitor quite so frankly about a non-disclosure. What had happened was this particular person, a lady, she was in a very bitter dispute with a very wealthy family, the husband of whom was one of the youngest children, and she had a property in her own name that she had built up the equity in over a long period of time and did not want to lose that equity, which it looked as though she could. So she sold the property without anybody knowing. and she dispersed of approximately $1 million of cash in about 24 hours, and none of it went through bank accounts, and none of it was traceable, apart from the general proposition said by her to be that it's with friends and they're taking it to Russia. So that was, it wasn't actually that amusing, even though it was ultimately a serious question where the advice had to be given that she was highly unlikely to get away with this, and the court would order her to provide an affidavit as to where the money would be or is, and to provide proof of that. And I guess the avoiding nature of the person in the first place to have got into that position thought that the advice I was giving was weak advocacy and just not supportive, and so I and the solicitor got sacked. Now, as it happened, that was quite a relief, because there was really only one way for that person to go in the eyes of the court, and it was not going to look good. So we all know that, you know, according to the approach clients take, we have to guide them, and some of them react very differently, some positively, some not so positively. So that's one ethical issue that can arise, more perhaps in family law than some other areas of law. Now, there's a big area where the migrant families, and this is now onto the second bullet point of parental involvement, migrant families who basically have money overseas, and one of their children ends up becoming a citizen of Australia, and that child then marries or enters into a de facto relationship with an Australian, and then that couple have children. There's an emerging trend where the parents who have accumulated a lot of wealth bring money from their country where they stay, and they put it in Australia into real estate in the names of their child and now their child's spouse. And as we all know, that then sort of complicates the level of interests that those four people have in the property. At an equity level, of course, that would normally be just within the equity jurisdiction, and it will come down to resulting in constructive trusts. But in the family law sense, when there is also coupled with that property dispute a relationship breakdown, so a marriage breakdown or a de facto relationship breakdown, the Family Law Act is overlaying all of that equity issue. And so there is an ethical question for all of us who are advising the third party, which is the parents overseas, when they seek advice about where they should start their proceedings. Because as soon as their child falls out of love with the person in whose name the property is that they paid for, they all of a sudden want their money back. And that's to be understood, but they are unfortunately caught to a very large degree by the auspice of the Family Law Act. So what there seems to be a trend of is an advice being given to those third parties that the best place to commence proceedings is in the Supreme Court. And the reality is only in very limited circumstances is that the case, because if there really is an underlying matrimonial cause, being their child is married an Australian, then the Family Law Act will apply. So the ethical consideration is whether you do commence in the Supreme Court or whether you commence in the family court. And there is definitely a trend of people choosing the Supreme Court because they see it as a superior court in terms of speed and the way in which you get access to the justice, compared to the family law court, which is well known for delays and two-tier system, and people have different views of those two different courts. And so I think it is an ethical problem that people face when they try and forum shop to get perhaps a quicker solution in the Supreme Court, except that they then face the real question of transfers to the family court or cross-vesting applications under the Cross-Vesting Act, and or applications for the stay of the proceedings pending the conclusion of the family court proceedings. And the reason it's ethical is not just the analysis, but also, frankly, the cost. Because what can happen is you can have two proceedings, one in the family court started by the other party that thinks that's where it should be, while you've commenced proceedings in the Supreme Court, and the amount of cost that is incurred by the two sets of families is just incredible. And so that is a big consideration, and something to watch. The time when the court's most likely to cross-vest or transfer Supreme Court proceedings from the Supreme Court to the family court is when there's an overlap in evidence, a likely inconsistent finding in evidence about through cross-examination and that sort of stuff, so that there's no abusive process occurring by all of those issues being ventilated twice. Now, the next point is private contracts versus binding financial agreements. There are definitely citizens who decide between themselves before they get involved in family law disputes to enter into private agreements, deeds of settlement, and use private contract to try and effectively contract between them out of rights that they might both have under the Family Law Act. Again, those sorts of things can often end up in the district court or the Supreme Court, where specific performance orders are sought. But the reality is, if they arise from a broken relationship, then they will very definitely have to be ventilated in the family court, not just as evidence, not so much a binding agreement. And they are different from binding financial agreements, which do have to meet conditions under the Family Law Act. But unfortunately, a lot of clients don't understand the difference between the two. They think their contract will bind, and they can end up self-represented commencing proceedings in the Supreme Court. So the ethical consideration then, when you're dealing with some of these unfortunate self-represented people on the other side, is to say, well, you know, despite what you think, you have to be in the family court, you have no choice, and that's where you're going to end up. Now, there's another trend, and people ask me if there are any family law trends coming out of COVID. There certainly are. In the last few months, I've had a number of briefs where my client wishes to defend a binding financial agreement that she or he has entered into in the last 5 years. But because there are opportunities to set them aside under the Family Law Act, people are trying to do whatever they can at the moment to find ways to use the various means to set these agreements aside. And the trend is definitely at the moment that people are taking every opportunity that is not necessarily available under the Act. In other words, they're taking a chance. There is some encouragement of people to have a go because of the anecdotal expression that binding financial agreements are not worth the money, the paper they're written on. And the reality is they actually are if they're done properly. And there's very much, in my view, an ethical aspect to advising someone who wants to set aside the binding financial agreement, because there really are only certain ways to achieve that. And just feeling like it's an unfair agreement from 5 years ago is not going to be good enough. There's another trend, which is the next one: financial relations after binding financial agreements. People enter into these agreements, they do so in good faith. Then they realize that their relationship is not as bad as they thought, so they continue living together in a house that one or other of them has received under the settlement. And so that causes one of them to feel 5 years later, after they've been continuing to apply money towards the property that they're living in, which they don't own anymore, that they have an entitlement. So that's another basis on which they try and set the binding financial agreement aside, and it doesn't work. What does work is an argument that there's another new relationship instead of the relationship that has just been terminated. Finally, I'm just going to go to the very last point now: scorched earth ceremonies. What I mean by that is an aggrieved spouse will often feel as though the way in which their ex-spouse is behaving towards them is that they want to burn them to the ground, so the other party will try and do the same. And the ethical aspect that comes into this is just trying to persuade people that trying to use the Family Law Act to achieve some sort of vendetta is entirely inappropriate, and that settlement or resolution is a much better approach. And there's a real overlap between ethics and advice, and basically that's an area where it can be very tricky, and the best advice sometimes is just to resolve it. I've probably gone a bit over time there, Michelle, sorry.
That's all right, Giles. Thanks, everybody. Our next speaker is Tom Bagley, and Tom will, hang on, I've just lost my page. Tom will talk about class actions and the ethical considerations in relation to that enormously large area of law. Over to you, Tom.
Thanks, Michelle. What I'm mostly hoping to talk through are some of the conflicts that can arise in class actions. And I'm looking at this from the plaintiff's perspective, not only because that's a lot more of what I do at the moment, but also because it's more complicated in terms of the existence of duties and conflicting duties. Because I've only got 10 minutes, I'm going to assume familiarity with the class action regime, but that might mean that some of the points that I will make might not be as relevant or accessible to people who don't practice in the area. The two core conflicts that I see arising are those between the interests of group members and the interests of litigation funders, the latter of which lawyers don't owe duties to, and also between various classes of group members. And sometimes that can give rise to the issue of conflicts between duties owed to different classes of people. I'm going to make 3 points in the time available. The first is not all of these duties are equal. The second is, although funders have a legitimate and central role to play in class actions, there are times where that role can create conflict. And the third is that the conflicts are particularly acute at the start and the end of class actions. So dealing with the first point, and this is something that is particular to class actions, I think, although there are probably some areas where there are analogous circumstances that arise. Not all duties owed to clients and quasi-clients or group members are equal. There's effectively a continuum of responsibilities ranging from the strongest duties, which are owed to the lead applicant that you have a retainer with, going right down to group members who you might not even know the existence of or the identity of, and who you have no contractual relationship with. So dealing with the first of those categories, the duties owed to a lead applicant who actually retains you are typically similar to the duties owed to a regular client in inter partes litigation. But a feature of class actions that isn't often seen in other cases is that it's quite common for a representative applicant to contract out of day-to-day carriage of the matter and hand over responsibilities to the litigation funders. That's something that courts have accepted as appropriate, but it does impact on the duties you owe to the lead applicant. It might no longer be appropriate to take day-to-day instructions from them if the retainer says they're not the person who gives those instructions. That's the simple case though. The more complicated case is the case of the duties that might be owed to group members. And there are group members who solicitors will have a retainer with, and then there are group members that there will be no retainer with. Dealing with the first category, those group members who you have a retainer with, you'll owe similar duties to the duties you owe to a lead applicant. It's just that the occasion for considering those duties won't come up on a day-to-day basis. It'll only come up where there is a part of the case that actually affects the rights or interests of that particular group member. So an issue that the full court of the federal court recently dealt with in the MH17 settlement approval, the Gibson decision, was a circumstance where there had been effectively a compromise of the claim of a particular group member who did have a retainer with the lawyers. And unfortunately in that case, the lawyers hadn't decided to inform the group member who had retained them of the fact that they were going to compromise the claim. They did it without instructions. The court said quite obviously that at the very least the duty owed to that client would have required the client to be told about the fact of the application, the evidence against them, to get instructions about the evidence in the application, and to advise them on the appropriate action and actually represent their interests rather than abandoning their interest. That all seems relatively straightforward, but the fact that it ended in the full court clearly shows that these are not issues that necessarily everyone understands clearly. There's then the situation of, well, what happens to a group member in that position who you don't have a retainer with? What's the nature of the duty, if anything, that you owe to them? And there are a few decisions about the nature and scope of that duty. It may or may not be fiduciary in character, but it is a duty to act in the interests of group members. And it's a duty that's found effectively in the structure and scheme of the legislation. So practically, what that would mean in the MH17 example is you don't owe quite the same level of duty to obtain instructions, act on behalf of clients. But what you do need to do is at least notify group members who you do know the existence of that there's an application that may adversely affect their interests. And unless those group members decide to retain you, that's likely sufficient to satisfy the duty that you owe to them. There are some very complicated questions that arise where you have group members whose identities are not even known to you. And I've been involved in cases where even the existence of particular types of group members wasn't known to the solicitors. There's very little guidance and authority about the nature and scope of the duties owed in those circumstances. But courts generally will take a practical, common sense approach to the nature of your duty and whether you've complied with it. If you think you're doing the right thing and you've carefully thought about it, you probably are. So turn to the second topic, which is, well, what about the role that litigation funders play? The High Court said their role is legitimate. They can fund cases. They can also run cases and give day-to-day instructions. That causes a little bit of a problem, or at least has the potential to cause a problem, because the lead applicants who the notional client or the actual client will be around for a particular case, but then they'll go. The funder might be someone who you have a day-to-day relationship with, an ongoing commercial relationship with, and they're often the person paying the bills. There's at least the potential for those factors to inform decisions that are made by solicitors and barristers, because natural self-interest does unfortunately affect decision-making. And it's important to bear in mind where there is a conflict between the interests of the funder and the interests of group members, that it's the interests of the clients first and foremost, and then unretained group members second, that is paramount, and not the interests of the funder. And so two situations where this can arise are at the start of the proceeding and at the end of the proceeding. And at the start of the proceeding, there's the commercial conflict that arises in negotiating the funding agreement. Is it necessary to go and obtain alternative proposals from other litigation funders? Is it possible to do that? Is it necessary to negotiate the terms and drive the hardest bargain possible? That can give rise to really complicated situations, particularly where the funder is asking the solicitors to run part of the case on a speculative basis. And then there's a conflict again between the interests of the solicitor and barrister in being paid as much money as possible, as much of their fees up front as possible, and potentially the interests of group members in paying the lowest funding commission. Another issue that arises at this early stage is when you're developing the claim and the definition of the group. That is, who will be allowed to be a part of the proceeding and what claims will be advanced. If no one's signed up, there probably aren't any duties owed at that stage. But if there have been people signed up through a book build process, it's important to step back and carefully reflect, have I discharged my duty to all of the people who have signed up? And am I running the claims that they want me to run and that will achieve the results that they want? And then the final point I want to talk about, and the final area where this issue arises, is at the compromise stage. And again, both of the conflicts that I identified at the beginning of the presentation are present here. You've got the interest of the funder in getting the best return for the lowest outlay. You've got the interest of group members in getting the best return no matter what the outlay in many circumstances. And you've sometimes got complicated questions about group members being treated equally or fairly. If you've got if you're running a negligence action and some of your group members have a pure economic loss claim, is that weaker? Should they be taking a discount? These are difficult questions that you need to work through to ensure that the settlement is fair, not only from a top dollar figure, but in terms of how it treats the disparate classes of people. And then finally, you need clear instructions from whoever you act for before agreeing to the compromise. That's a quick run through. Michelle?
Thank you, Tom. Our final speaker is Frank Tao. Frank is one of the more junior members of our floor, but not a junior lawyer. Frank will talk about a number of practical considerations for avoiding common conduct issues in insolvency practice. Thank you, Frank.
Thank you, Michelle. Good afternoon, all. I want to take a practical approach and just provide a couple of examples of common situations where insolvency practitioners and their advisors may find themselves in spots of difficulty, and also for those who act in insolvency-related disputes. The three points I wish to cover as follows. Firstly, difficulties a legal advisor might find when they act for a company and or its director prior to the insolvency or the external administration of a company. Secondly, issues of independence in relation to voluntary administrations and liquidations. And thirdly, a matter which probably extends beyond insolvency-related disputes, and that's ex-parte applications and the risk of material non-disclosure. Each of these issues I address have come up in the last year or so of practice, and therefore I think they may be of real concern to practitioners to ensure that they are addressed and considered at an early stage. Firstly, as a matter of acting for companies and directors, this is something which applies to both litigators and also our transactional colleagues in advisory capacity. Whether you're acting for a large company or a startup, one thing that may happen at the outset is you may not turn your mind fully to the person or the client for whom you should be acting. And you may, for example, put down in the retainer letter that you're acting for the company or one or number of companies in a group that's a subject of a startup, or for the director. Where that issue may unravel is down the track if one or more of those companies enters the external administration, and there may be a contest about, among other things, the propriety or adequacy of the conduct of the director and or the nature of the company's books and records and its completeness. An issue may come up, for example, if the solicitor was previously acting for the company and the liquidator now seeks to access or rather demand all of the company's books and records. Now, the liquidator has a statutory right to do so under the Corporations Act, and no third party can resist that claim without the leave of the court. So you have a situation there where if you're continuing to act for the director of that company who's now in external administration, there's a tension that rises as to how you ought to fairly deal with those court documents, which may, for intents and purposes, be essential to the dispute that director may have against the liquidator or vice versa. Now, this was something that came up recently in a matter on which I was instructed. And the solicitor was acting, it appears, at the time for the company. Now, a substantial way through the litigation, but before the hearing, the solicitors for liquidator took an issue with my instructing solicitor's use of those documents and his overall involvement in the proceedings, saying there was potentially a misuse of documents or breach of confidentiality of documents which belong to the company, and secondly, the solicitor's role in that matter. So the key takeaway I want to draw to your attention is to consider carefully at the outset for whom you wish to act. It may be in a variety of situations, you may wish to have a plurality of engagement letters for each of your clients or potential clients, and or to make clear in the documents that you produce as legal advisor that they prepared subject to common interest privilege, so that you may still retain the benefit of some of those documents down the track. Now, a practical example of why such documents can be an issue for those who do not practice predominant insolvency is to look at a liquidator's right against a payee for what is known as unreasonable director-related transactions, and that is under 588 FDA of the Corporations Act. Now, there's a provision, subsection 3 under that provision, which basically provides that a transaction may nevertheless be an unreasonable director-related transaction, even if the transaction is given effect to or is required to be given because of order of the court. So one instance when insolvency disputes may very frequently traverse and intersect with family law disputes is where you have a family law property dispute, and that dispute involves a division of matrimonial assets which are being held in a family company or SPV. And practitioners need to bear in mind that family court orders can still be attacked and unwound potentially in insolvency proceeding. So that's a dimension where I think it's very prudent to consider down the track what may happen to documents produced before a company enters insolvency. The second matter I wish to touch on briefly is independence considerations. Now, it's unclear at this stage whether the federal government's relief measures will end in September, or as many in the industry suspect, there will be an extension of some sort in mid-September, given the current state of play in Victoria and to less extent in New South Wales. But what is telling down the track is that as at 30 June 2020, Australia had 633 registered liquidators, down from 711 in 2000 at the same time in 2018. Now, ASIC has fairly candidly mentioned at a recent Parliamentary Joint Committee on Corporations and Financial Services that a very potential risk is firstly ASIC's oversight of the corporate insolvency once we fall from the cliff face, so to speak. And associated with that is whether the insolvency profession has enough registered liquidators or insolvency practitioners to deal with what is expected to be a calamitous number of insolvencies, whether that is external administrations, receiverships, or liquidations. And the difficulty for that is if you don't have enough liquidators to go around and to serve the various companies that may need to be managed in external administration, that puts to the fore the issue of independence. The independence is very simple, is simply described, but hard to I suppose enforce. And the simple measure is you need to be independent and to be seen to be independent. Practically for external administrators and liquidators, that is generally documented through what's called a DIRI, which is a Declaration of Independence, Relevant Relationships, Indemnity, and that needs to be presented at the first meeting of creditors. The practical difficulty, I suppose, is that if you have not enough liquidators and they all need to juggle these various insolvencies, there's going to be a real issue as to what they can do and what they can't do in terms of accepting appointments. Now, I'm not here to provide a panacea to say, this is a magic wand to deal with that. And the reality is it's going to be on a reactionary and common sense approach as to how insolvency practitioners deal with those issues and where the appropriate applications to court needs to be made for directions having regard to the circumstances and the state of perhaps the nation's economy at any one time. But I think it's a relevant consideration for lawyers and insolvency practitioners to be alive to that issue so that their own conduct is not attacked down the track, whether it is by creditors, by ASIC or another stakeholder. Now, related to that is more frequently than one would expect, a lot of companies go into voluntary administration. And the object under a voluntary administration is very different to that under liquidation. It is basically, in simple terms, to either save the company or to provide a better return to creditors than a company would achieve in liquidation. Now, a common theme that comes out of voluntary administration is that the company is rescued and is repackaged and sold. Now, news today, I think, following the rumours a few weeks ago, that CPD, the the retailer of Australian swimwear is going to be sold back to its owners. Now, initial reaction to that is, of course, well, how could that be? You know, they've caused that business to go insolvent, and now it's going back to them, and not all shareholders have been paid 100 cents in the dollar. The reality is that the voluntary administration regime does provide the potential for the existing owners or someone related to them to pay fair and reasonable consideration to reacquire the interests of the business. What needs to be borne in mind is that there obviously needs to be a proper process so that the business is put to the market and its fair value is achieved. Now, that is relevant, I think, for insolvency practitioners and advisors who are advising clients in their businesses, is that what is a typical mistake that is made is to say, in layman's terms, we'll put your company into voluntary administration, there'll be a deed of company arrangement, you'll come out and you have the business. There's a fine line between indicating that is a potential option, and in many cases, a very realistic option, and on the other hand, promising that is going to be the outcome, because that is, in effect, suggesting to your client, on one view, let's Phoenix the business. So I think there is a very careful line that needs to be observed in such instances, but that should not necessarily foreclose the destruction of the business or the savior of the business. Now, the final matter I wish to talk about is fraud and material non-disclosure. Litigators will, of course, be aware that many fraud matters start in the duty judges list in the Equity Division of the Supreme Court after a frantic 24 or 48 hours of putting the court papers together, and you're rushing about trying to get the freezing order and to preserve what assets you have. It's fair to say that a downturn in economy, increase in insolvency, generally correlates with an increase in the number of frauds or misappropriation of assets that are identified. What I would like to stress is both for litigation brought by insolvency practitioners and otherwise litigants generally, is to re-emphasise the importance of giving full and frank disclosure on an ex-parte application. We've all heard it before, but very rarely do we hear about the unravelling of a case because of it. I'm involved in a matter in the Supreme Court acting for a defendant who's a CFO of analogous role in a SME business. And very recently, there was an application brought by one of the other defendants, a family member of my client, before Justice Parker. And they sought to set aside an ex-parte freezing order obtained against them on the basis of material non-disclosure. And what occurred was that when you unpacked all of the evidence, there were very real defences that could have been raised and ought to have been disclosed at the ex-parte application, which were not. The effect of that was that family member was put to the inconvenience of having a freezing order made against them. The impact of that freezing order was they had difficulty accessing the bank accounts, and those bank accounts included funds that were being used by that family member in a carer capacity for her mother. Now, that of course is likely to tug the heartstrings, but added to that was the plaintiff's reluctance to accept the existence of those potential defences and not providing any adequate reason as to why those matters were not raised on the ex-parte application. The outcome in that case was that the freezing order was discharged from the beginning and a cost order was made forthwith by Justice Parker. So we've heard it many times about full and frank disclosure, but here was an instance where we saw that proceeding unravel very, very quickly. And that kind of thing can happen to both insolvency practitioners, others who are generally in a rush trying to get things done and trying to get a court proceeding on foot. So they are the three takeaways I would like to present you with for your consideration. Thank you.
Thank you, Frank, and thank you to all of our speakers. We've got time for some questions. So if anyone in the audience has a question, can you work out a way to attract our attention? In the meantime, Andre, can I ask you, where there's a complaint that's being gone to trial between a client and a solicitor or a barrister, and the complaint could be answered by the referral by the practitioner to documents which attract legal professional privilege, but the privilege is the complainant client's, and the complainant client does not agree to waive privilege, what measures are available to the court or to the barrister or the solicitor in those circumstances?
Thank you, Michelle. Well, look, when it's the question of privilege really does depend on who it is who's bringing the claim. So in your example, where it is the former client who is suing the solicitor or barrister, or making a personal costs claim against the solicitor or barrister, or indeed making a disciplinary complaint, there's really an implied waiver of the privilege, and there's no difficulty with the solicitor or the barrister referring to the file, as it were, and the communications with that former client in order to answer the claim that's being made against he or she. But if in a different scenario, if the claim, for example, is being made by the opposing party in the litigation rather than the client, that can put the solicitor or barrister in a difficult situation, because they may have a very good answer to the claim, but it involves disclosing the privileged communications with the client, including, for example, express instructions or the like. And in that case, the practitioner can't breach the obligation of privilege, and disclose that material without the former client's consent. And that's why the motto in the extract that I've provided, you'll actually see in paragraph F, I think it is, of the considerations by Justice McColl, that where a legal practitioner's ability to rebut the complaint is hampered by the duty of confidentiality to the client, then effectively the court should give that practitioner the benefit of the doubt, bearing that in mind.
And so would that mean that in preparing an affidavit material, sorry, I appear to have dropped off, in preparing an affidavit material to rebut that, and where one didn't have consent to reveal privileged materials, the practitioner would say, in a sense, I have something to say, but I'm not allowed to say it because of privilege. So you would make sure the court understood that that was your problem, and without actually stating the material.
Yes, where it's a third party who's bringing the claim, not the client, and there was some privileged material, you would certainly want to point that out in your evidence, that there is something I can say, or I had a conversation on this particular date with the client, but by reason of privilege, I can't disclose what it is. Yeah.
And is that an effective way of dealing with it in your experience?
Look, it really depends on all of the circumstances. The case that I had very recently, there were instances where that was the approach that was taken, referring to particular conversations but not being able to disclose it. But it's only one of the relevant matters, so it really depends on the nature of the case. If it would be a complete answer to the claim to be able to disclose the instructions, and that's as simple as the case is, then that might be quite helpful to have the benefit of the doubt. But often in these cases, there are a raft of different matters, and not all of them fall within the rubric of privilege.
Okay, thanks, Andre. Now, does anyone else from our audience have a question? I know that, or I hope that Giles, Frank and Tom have a question as a backup, but does anyone in the audience want to metaphorically put their hand up? I can't see anyone jumping up and down. Well, I might throw to Giles, if that's all right with you, Giles.
I'm sorry, Michelle, to ask a question or answer a question?
To ask a question. I don't want to put you on the spot.
No, I'm sorry.
No, that's all right.
Perhaps while he's on the spot.
I'll move on to Tom, who I think might have a question for you, Giles.
I don't. I did have a follow-up question for Andre, though. In the context of a personal cost order application, just picking up what Michelle was asking about privilege there, if the court has decided of its own motion that a personal cost order may be appropriate, is that a situation where you can disclose privileged communications, or one where you can't?
No, I think it's the same situation where you'd be still stuck with the obligations of privilege to the client unless there was agreement.
Because on one view, what you're being ordered to do is effectively reimburse your client. So as between you and your client, it's the client who's getting the benefit of the personal cost order. And it would be odd if the client was able to rely on their privilege while at the same time getting the benefit of the order. But I can see why technically they're not the person making the application.
There might be a question, Tom. You raise a good point. I suppose if the client effectively joined in the application, that might be a slightly different situation. But I think otherwise, as a general proposition, if it's the court or if it's a third party, but not the client who is effectively making the claim, then I don't think that cuts through the privilege.
And Giles, a question for you, picking up one of your earlier topics about the nature of a solicitor's obligation or a barrister's obligation to avoid a multiplicity of proceedings or avoid excessive costs. Is it your view that your obligation is effectively to inform and encourage your client of the cheapest way to run a proceeding? And what are your obligations if a client decides to take the more expensive option? Are you allowed to continue acting?
In relation to the first point, I'm not sure you have to, the focus in my view is on the correct analysis. So the cost issue is a subsequent consideration, but the real analysis is that the Family Law Act has got the exclusive jurisdiction. The Cross-Vesting Act applies to provide the ability for the court or an applicant to get it sent to where it's best to be done. So that sort of throws out the cost issue. And as another consideration where you say, well, as a matter of advice, the reality is you're going to spend money there and then you're going to end up in the family court anyway, so you'll waste costs. But the first question is really, where is the proper forum? If they then say, well, I'd rather go that way, in other words, the more expensive, then that really does become a very personal, ethical question, because obviously you're a creature of your own instructions, and if it's open to the person to do that, then it's open to you, I think, to be instructed to do that. But as long as you've informed them of the risk or the reality of a likely transfer application or a cross-vesting application, there's a middle ground though. For example, in Section 66G applications, if two parties within a marriage co-own a property, then the Supreme Court will still potentially make an order for the sale of the property, but they will do so and likely make it subject to the money being held in escrow pending the family law issues being resolved. So it's not always absolutely clear-cut which way it should go. The remedies are available in both courts, and you've just got to be sensitive. But I have had a recent colleague ask me, can we get a practice note in the Supreme Court preventing people from making certain types of applications in the Supreme Court when they should probably be made in the family court? And so people are becoming aware of the ability to use one forum to drag another into a dreadfully expensive cost issue in the scorched earth ceremony that I was sort of describing.
Thank you, Giles, and thank you to our questioners. While I still have most of you with us, I wanted to give you a heads up. We have a CPD coming up, which is a little bit different to the type of format that we've had. We've got a single speaker. That speaker will be Jack Hines, member of our floor, who's a specialist in corporations and insolvency. Jack will give a brief refresher overview of the recent Omnibus Act, those measures, and also some recent pandemic-related insolvency cases. Jack's main topic will be a comment on the need for more meaningful insolvency law reform in order to ensure an efficient and fit-for-purpose regime in Australia. The recently enacted Corporate Insolvency and Governance Act in the UK is considered, at least by Jack, as an example of what might or should be done in the Australian jurisdiction. So we'll send out the details for that very, very special purpose focused CPD in the next few days. We think it will probably be in mid to late September. So in fact, that's really only a few weeks away. And I look forward to seeing you all at that special purpose CPD and when we resume regular programming. So thank you again for joining us. Don't forget that we are available online and occasionally in person. At least some of us are going into chambers every now and then. And I look forward to catching up with you all then. Thanks again. Bye.